The Historical Society of the United States Courts in the Eighth Circuit was incorporated as a not-for-profit organization in May of 1985. The purpose of the organization is to collect and preserve historical information of the United States courts in the Eighth Circuit. The Nebraska District Court Historical Society was formed as one of the 11 branches of this corporation. As part of its efforts to gather historical information on the Nebraska District Court, the Society presents this oral history by the Honorable Robert Van Pelt, who served actively on the District Court bench in Nebraska from 1957 until 1970 and is currently serving as Senior United States District Judge. I am Richard Shagrew of the Creighton University School of Law. Judge Van Pelt, you came to the study of law after being a boy in Gosper County, Nebraska, going to Doane College in Crete, Nebraska. What were the influences on you to take up the profession?
Let me back up with you a little on that. The custom at that time seemed to be that a woman was going to have a baby and her mother was elderly. She'd try to go to the home of her sister, and that's what my mother did. So I was born in Gosper County at the home of an aunt. The mother then immediately returned, or almost immediately, to Stockville, the county seat of Frontier County, where she and my father had been living for several years before that. My father and mother were divorced within a year. Mother stayed on in Stockville and ran a boarding house and what we called a restaurant or eating house. And I continued to and went through the schools at Stockville, which only had 10 grades. You had to go away if you were going to go to college. And I attended the Congregational Academy down at Franklin, known as Franklin Academy, for 2 years. There I received a scholarship to Doane College, and hence I went to Doane College and followed that up by going to the University of Nebraska Law School. It's difficult to analyze and be at all certain as to how you became a lawyer or would start out thinking you would be a lawyer. The two most important things that took place in Stockville in my boyhood would be court, which was held 2 times a year, and the county fair. I'm quite sure that the court being held, seeing the men that were coming, particularly the lawyers and the judges, many of whom ate their meals at my mother's, helped to bring me into contact with the legal profession. As I get older, I give even more weight to an incident that happened to my mother as a young so-called immigrant girl when she was working over at Denison, Iowa. She attended a Sunday school class that was taught by a young lawyer who later became the governor of Iowa, later became the Secretary of Treasury under Theodore Roosevelt, and still later became a Wall Street lawyer and banker. And I am sure that my mother formed an impression as a young girl that a lawyer was somebody who stood out and that she wanted her boy to be a lawyer. With the result that she said to me one day that she could make her living in the restaurant if I could work my way through law school. And that I attempted to do.
What kind of work did you do when you were in law school, Judge?
2 or 3 different things that broaden your question, or I'll broaden it for you beyond law school. I was out of school 2 years between the academy and college. The county treasurer, I started out teaching a country school. Then later I was the deputy county treasurer in Frontier County for a year and a half. And one day the county treasurer said to me, in substance, Robert, why don't you go out this spring and try to write some hail insurance? I think you could make $50 if you would go out writing hail insurance. I was getting 25 cents an hour, so that looked like a lot of money. I did that very thing. My mother was away that week. The first night that I came home from writing hail insurance, and I had ventured spending $7.50 with a fellow who had a Ford to take me out around and see the farmers, I had made $100. I didn't believe there was that kind of
Must
money
have
in the
seemed
world.
like a fortune, huh?
It did. And when my mother came home, I told her, Mother, I can go to college this fall. I've made $400 this week. I wrote hail insurance as I went through college. I sold books as I went through college, actually for Jim Wick, who's recently given a building down at the University of Nebraska,
Yes.
and for his brother. And then I had a job waiting on cable that also helped me out.
Mm-hmm.
So those are the things that I did during the summers and as I was going to law school and college.
There's some apprehension in the 1980s that young men and women who graduate from law schools will find difficulty obtaining employment. What was the job market like for the young lawyer in your youthful days?
I was fortunate, I think. Ernest B. Perry of Cambridge, Nebraska, the district court judge in the district that you and I would call the McCook district,
Mm-hmm.
came to Lincoln in 1919 to practice law because he couldn't send his children through college on $3,500 a year, which was the salary of a state court district judge at that time. I ran into him one day on the street buying some forms to prepare a petition to foreclose a mortgage as a part of my work in the mortgage course. He asked me to come over to his office. I accepted the invitation, and a day or two went over there. He told me that that office, Stewart, Perry, and Stewart, were looking for a law student to work a couple of hours a day at 50 cents an hour. I took the job. The next fall, I worked 7 and 8 hours a day. They offered me a job. I stayed with Judge Perry for 25 years. He separated from the Stewarts, and the firm became Perry and Van Pelt, then Perry, Van Pelt, and Marti. Then Marti and I separated from the Perrys, all friendly, and we started Van Pelt, Marti, and O'Gara. I continued the practice in that way. So, in a way, maybe I lucked out by running on to a fellow that I'd known as a boy who had been a state court district judge.
Mm-hmm.
And was my partner for 25 years.
What was the curriculum in law school like when you were attending? Of course, those were days when a number of persons came to the bar by studying in a so-called preceptorship in a law office. The school must have been somewhat different from what the young people today are used to.
And as you're aware, that continued, I believe, through the governorship of Val Peterson. And I mention him not because he had anything to do with terminating it, but he was one of the last persons as registered in a law office
Mm-hmm.
that of whom I with whom I'm acquainted.
Mm-hmm.
I think we took much the same courses that would be given now. I haven't attempted to recall them exactly, but doing so quickly, it's my recollection that we took the first year contracts and torts. We had pleading and practice. I would have to think longer than we should take
Real
on
property.
telling you real
Real
property,
and personal
and
property.
that was taken for 2 or 3 years.
Mhm.
I can recall that we had quite an argument, and I led the group that was asking for it, getting the law school to teach bankruptcy.
Mhm.
Because we had one professor who said, well, about the first thing that'll happen to you when you get out of school, some fellow who's bankrupt will come along and want you to take him through bankruptcy, and you need to know something about the bankruptcy law.
Mhm.
And we were told by the faculty at that time, well, that'll be repealed any time the Congress wants to repeal it, so we don't teach such subjects. They installed the course, however, and so we took it.
When you were called to the bar, of course, there was an examination for admission. Do you have any recollections at all of the examination process for admission?
No, I go back so much further than you're thinking. There was no examination when I was admitted. It was then the rule that if you were a graduate of Creighton or if you were a graduate of Nebraska, that you were admitted to the bar on motion.
That was a diploma privilege, in
That
other
is a
words.
diploma privilege, which I still favor.
Mhm.
You may not.
I think there are only a couple of states in the Union left, Wisconsin being one of them, for its local schools that has such a privilege. Most states, unfortunately, at least from the students' point of view, have done away with that.
Yes.
What kind of conditions did a young man, and I assume for the vast majority of the lawyers 60, 70 years ago, there were young men who were starting out in the practice. What kind of conditions did they face in a in a law firm?
The first thing that I would think that I faced was the matter of examining abstracts. No one around the office wanted to examine abstracts. They examined them for a building and loan, and so examining abstracts was shoved over to me. I examined a lot of abstracts for a while. Then I was in the office in part to help Judge Perry, who had a large practice out in southwest Nebraska, and by him was pushed into the matter of trying lawsuits.
Mm-hmm.
And then also in the writing of briefs in the Supreme Court and lawsuits that he had tried and was going to argue.
Mm-hmm.
And I was given the opportunity to argue many cases.
So that very early in your career, you were thrown into a very well-rounded practice.
Very well-rounded practice. First of all, I got to argue a case against the fellow who had taught contracts at the University of Nebraska, Cocky Robbins.
Mm-hmm.
You can guess that for a young law student just out of school, that was a great honor.
Mm-hmm. Mm-hmm. Your loyalty to your alma mater of Doane College has lasted for many years. You served for, I think, a number of years as a member of the Board of Trustees at Doane, didn't you?
Doane honored me early by electing me to the Board of Trustees, and so I served 40 years on the board. Realized at the end of that time that if I continued to serve, I would, if I lived at all long, serve longer than any other person.
Mm-hmm.
And I felt very definitely that a certain man who had left his entire estate to Doane College should continue to be recognized as the man who had served the longest on its Board of Trustees, and I retired.
Mm-hmm. Well, Doane also honored you with an honorary doctoral degree,
Correct.
didn't it? Yes, it did.
Yes.
In addition to the practice of law, the service at Doane College, you had a very full life in partisan politics prior to going on the bench, and nonpartisan politics as well. So you served in the school board in Lincoln, and you served as a delegate to the Republican National Conventions at least 2 or 3 times, didn't you?
3 times, and we never nominated the man who was elected president.
What was the service on the school board like?
I was in my office one day, and 2 men, Paul Good, later Attorney General, and Arthur Dobson, a Lincoln contractor, came in and laid on my desk a petition and said, "Bob, this is a petition that will put your name on the ballot to run for the school board." And I looked at it and said, "Who would I be running against?" And they told me the name of a man that was a client of the office and had been very friendly to me, Dr. Bailey, who ran the Bailey Sanitarium. And I said, "I won't run against Dr. Bailey." 2 years later, they came in and went through the same ritual and said, "Dr. Bailey will not be running this time." So I ran for the school board. There were only 2 of us ran for 2 positions, so we were both going to be elected.
Mm-hmm.
And they were meeting at that time in the mornings, and I concluded that I could not give 1 morning a week. And the school board, probably correctly at that time, thought they shouldn't have evening meetings, so I retired at the end of 1 year.
Mm-hmm.
And it is simply a matter of rotation, that if you serve 6 years, you'd be president one of the 6 years.
Mm-hmm. Mm-hmm. What kinds of experiences in the community, and you were and had been very active in the Lincoln community, what kind of experiences in the community would you suggest are important for the lawyer getting started in his or her career today?
Well, I think to build up an acquaintance is an important thing. Once you get law business, then it's a matter of how well you can handle it and whether you gain the confidence of people. The United States, the Junior Chamber of Commerce, in my day in Lincoln, was a good way to get acquainted. And so I became a member of the Junior Chamber and went through the various roles, became its president, served on the National Board of Directors, did things of that kind, and I'm sure broadened my acquaintance.
Mm-hmm.
I have never run for an office that paid a salary. I did file for a delegate to the Republican Convention in 1940, 44, and 48, and I should call to your attention that I started out as a Democrat. On the debating team at the University of Nebraska, I argued in favor of a League of Nations, which was opposed by Senator Norris and which Woodrow Wilson wanted. My first ballot was cast for Governor Cox and for Franklin D. Roosevelt running for vice president. And I have never regretted my belief that had we at that time had a League of Nations, we might have saved some wars.
Mm-hmm. When you first came out of law school, the United States District Judge who was residing in Lincoln was Judge Munger.
Correct.
You have fond recollections of Judge Munger?
Very. I, in 1930, was appointed the Assistant United States Attorney. At that time in Lincoln, the job was a part-time job. Charles E. Sandall of York had been appointed the United States Attorney, and he came into our office inquiring about one or two people that he had been told were possible persons to be appointed the assistant in Lincoln, who had charge of Lincoln, Hastings, and McCook. And in those days, had complete charge of those three districts, and then Omaha handled the rest. I mentioned to Judge Perry, who had called me into the conference, that I thought I might be interested in being the Assistant United States Attorney. Don Stewart, who had been our partner, and Stewart, Perry, and Stewart had been the Assistant United States Attorney, and I saw how much it did for him in the trial practice. And Perry's remark was, well, if you'd have told me that sooner, you'd have been the United States Attorney, which I think he was simply puffing me up. But anyway, Sandall appointed me the United States Attorney, the Assistant United States Attorney.
Mm-hmm. This inevitably then cast you in a position of probably very frequent contact with the United States District Judge.
It did exactly that. My office was right above his. There was a method of going down to the courtroom, which was right below, and then going into Munger's office, which he gave me a key to in order that I would have access to the books. And I became very well acquainted with Judge Munger, and I'm sure that entered into later decisions in my life, being interested in being a United States judge.
What was practice before a United States court like in the early days of your career?
In the criminal field, it was mainly the prosecution of prohibition cases. We had an interesting thing in Nebraska at that time. Munger believed in the national prohibition law. Judge Woodrow of Omaha, did not believe in the national prohibition law. Cases in Omaha you filed under the Internal Revenue laws. And Woodrow would then prosecute, or not prosecute, but hear, and then sentence severely any fellow who failed to pay tax on the liquor that he made. But he wouldn't stand for a prosecution under the Prohibition Act if he could avoid it. Munger was the other extreme. You didn't prosecute before Munger under the Internal Revenue Act. Then there were many other things that came along. Roosevelt introduced, and there was passed the National Recovery Act, and that began to result in a great many cases in the office. We had many bank failures and prosecuted a number of officers of national banks. We had some stolen motor vehicles and, of course, breaking into boxcars and the like, railroad cases.
Each person who serves as a United States judge, of course, has his or her own personality. I think as younger lawyers, we sometimes look at an individual who's in such a high and awesome job and perhaps model ourselves after those judges, even subconsciously. Was there such a judge after whom perhaps you subconsciously modeled yourself when you ascended to the bench?
I expect that the answer would be yes to that, and in turn answering it that way, I would have to say both Judge Munger and Judge Delahunt. I thought very highly of each of them, and each were unusually competent judges.
There, of course, were two Judge Mungers in our district court history, not related to one another at all. Tell us about the other Judge Munger.
Judge William H. Munger came from Fremont, Nebraska, and practiced there for many years with a man by the name of Courtright. He was appointed in the last days of the Cleveland administration after a very competent Omaha lawyer by the name of McHugh had been nominated, and his nomination was held up by Senator Thurston, with the result that in the closing days of the Cleveland administration, William H. Munger, who'd been a Democratic candidate for Chief Justice, for Congress, for one or two other offices there in Nebraska, including, I believe, he ran one time for governor. He was named. I never met the man, but he was regarded as a man who disposed of business in good shape. Munger was appointed in 1907 after Elmer Burkett, congressman and then United States Senator from Nebraska, had introduced and secured the passage of a bill creating a judgeship with a judge stationed in Lincoln. That went into effect on March 1, 1907.
And he served then into the 1940s.
He served into the 1940s, was preparing to retire, walked out of his office one noon, out onto the street, and had a heart attack and lived only a few days thereafter.
Now, after his appointment, who was the next federal judge who lived in Lincoln?
The next federal judge in Lincoln was John W. Delahunt, who came from Beatrice. And I don't know how much history you want on some of these things, but
you did share with us informally a wonderful story about the integrity of Judge Delahunt as he was a young student at the Creighton University Undergraduate School in Mathematics.
I'll be glad to do that. And before we touch that, if you'll let me just mention one matter that I have failed to mention to you that may be worth mentioning when you're talking about history. Senator Norris, of necessity, was deeply indebted to Christian A. Sorensen, a lawyer of Lincoln, who later was the Attorney General of Nebraska, and whose son was a speechwriter for John F. Kennedy, and one of his sons was one of my law clerks, and so forth.
Who is now, I believe, a professor at Ohio State.
Ohio State, that's
University.
Right. That's Phil Sorensen. Sorensen's name had been submitted by Norris to President Roosevelt, and the story is that he had prepared for him, and there was lying on his desk the nomination of C.A. Sorensen to be the United States Attorney, a man from O'Neill, Nebraska, who had considerable status in the Democratic Party, came in to see the president that day and saw this nomination and complained about it, raised objection, with the result that Sorensen's name wasn't withdrawn because it had never been submitted, but the president concluded not to submit Sorensen's name. If you look at the 1941 Martindales, you'll find that it names C.A. Sorensen as the United States judge in Lincoln, Nebraska. So evidently from some source they had received the same information. Then following that withdrawal, John Delahunt was well-nigh universal choice, I believe, to be nominated for judge. Yes, I told this story in connection with the memorial service for Judge Delahunt that you have mentioned, and I'm glad to repeat. It was told that in his freshman year here at Creighton, he took the mathematics examination. He was a man with a great memory and memorized easily, and he took the first examination in mathematics and received a grade of 100. The professor didn't believe that anybody could honestly get a grade of 100, so he set aside the examination and ordered a new examination. It was given. And again, John W. Delahunt received a grade of 100. The professor then concluded that Delahunt was honest, that he hadn't cheated, that he was just that bright.
What kind of practice did Judge Delahunt come from down in Gage County?
I think it would be fair to say that the firm, Riniker, Kidd, and Delahunt, had the leading practice of Beatrice. Beatrice in those days was a town that had a great many of what out in the poor man's country we called money loaners. A lot of money was loaned out of Beatrice, Nebraska to farmers. John in the 30s handled a great many foreclosures. He also tried quite a number of cases because they had a substantial clientage in the number of the counties that adjoined Beatrice. But I would say primarily his practice had been an equity practice.
But a smaller community practice, a man who was not afraid, I suppose, to deal with people in a small community on a one-on-one basis, as of necessity you'd have to.
And dealt with them well, yes. He was well regarded in the entire community. Riniker was a very competent man. His son Sam was a classmate of Robert A. Taft at Yale and went into Chicago and established a good practice there. Mr. Kidd was a good practitioner. Likewise, he became interested in finances and was the president of the State Federal Savings and Loan Association for many years in Beatrice, in addition to his practice of law.
What kind of transition is there for the practitioner of the law as a new person comes on the federal bench and you've been used for 35 years or so to a different man, Judge Munger dying and Judge Delahunt coming on? Is there some kind of caution among the practitioner as to how they will approach the new jurist?
I'm sure that there is and always will be. Munger was one who lawyers were afraid many times to approach, and many lawyers were afraid to approach Delahunt. And yet both of them were very human people, and I always thought that each were easy to approach, not for the purpose of horse-shedding the court, but to ask about matters, settings, and whatever you wanted to know about. I always found them very cooperative.
But they retained the dignity of the court at all times.
Very definitely, and we must admit that all judges have eccentricities, and you must bear that in mind. Delahunt believed very firmly that the judge's interest was at the bottom of the list. First interest was the parties and the witnesses and the lawyers, and the judge came at the bottom of the list.
Over the years, there have been some changes in terms of the support services which federal judges have available to them. I know there's a wonderful story about Judge Harvey Johnson on the bench, a person who really did a lot of his own stenography work and so forth, stemming from his career as a law student when he had done that kind of work at the Nebraska Supreme Court. But other judges have had full advantage of clerks as well as a full professional staff. When did you start seeing that kind of development with the federal judges?
Munger did not ever, to my knowledge, have a law clerk. Delahunt didn't have a law clerk until he had served a number of years, and then he moved over to the law clerk system and had some excellent law clerks.
Is it true that the law clerk relationship with a judge is one that is just very difficult for outside persons to understand, because you must live together and breathe together and go through a great deal? Has that been your experience with your own law clerks?
Yes, I think it's very important that they be on good terms and be able to follow somewhat the same general lines of thinking. That doesn't mean that one runs the other, but they must cooperate, certainly. And now, of course, district judges rather usually have two law clerks. I think in the Eighth Circuit there's now one district judge and another state and district that I'm told has 4 law clerks.
Is that correct?
I don't know just how that's justified, but I'm not saying that the man isn't entitled to it. He's a competent judge.
In terms of the caseload for the federal district judge, as you've described the burgeoning cases during the 1930s and the Depression time, the financial type cases, I suppose there would be parallels to the number of cases that the active federal judge faces in the 1980s.
But not equal. The judges face more cases now, and no small measure by reason of what I will lump off generally as the civil rights cases.
So that you would have those so-called 1983 and that genre of lawsuits today, plus everything else that would be on
Yes.
the judge's docket.
I recall at one time when I was still the active judge of having 100 civil rights cases. Now, I don't know how many Lincoln has now, but that was quite a number of civil rights cases in addition to the other load.
Hmm. In your early years in practice, Judge, what kinds of insistence did the federal judges have on moving cases along on their dockets?
It was mainly by use of the jury system of having a call of the docket. And you'd give the opportunity to either side, if they wanted a continuance, to raise the questions as to why. Then the judge would set the case at the call of the docket. And they could use that rather effectively, convincing the lawyers that the next term of court, your case is likely to be reached for trial, and setting them differently than they're set now. You'd set a big string of cases, maybe 18 to 30 cases, all on the docket at one time, and reach them when you got to them. And it put a burden on the lawyers, but it does, in my opinion, speed up a docket.
Are there inevitable conflicts that occur of those persons who are particularly active trial lawyers who may be called to try a case in the federal district court, but at the same time perhaps at the state courts? Have you heard lawyers complain about docket management as it relates to those conflicts?
Yes, and that is always a problem. It's always a problem between state court judges where a man has business in more than one district.
Mm-hmm.
And the judge has to use some common sense and work it out. There are likewise some fellows that are dilatory, as I think you well know, and are always glad to get their cases moved over, and the judge must take that into account.
Mm-hmm. When you were appointed to the United States District Bench in 1957, Judge Delahan then moved to senior status. Is
Correct.
that correct? And left the city of Lincoln and came to Omaha.
Well, he didn't leave for a year or so, but he did leave within a year or two. Almost immediately after he was appointed the judge, he went up to Maine for several weeks and did that following what was characteristically John W. Delahan, who told me that he was not going to sit around and look over my shoulder,
Mm-hmm.
that he thought that I should be running the docket there for the first time and without his being around or where he could be called on in any way.
Your experience, of course, as a trial lawyer was such that was legend in Lincoln and still is today. One person said of you that you had tried more cases than any other person active in the practice of law in the entire state of Nebraska. Is that recollection one that jogs your memories at all?
Yes, I know that has been said. I have never attempted to prove it or to disprove it.
What do you think are the major factors that contribute to the appointment of a United States District Judge? We know, of course, the integrity of the individual, the learning, the respect the individual has in the professional community, factors like that.
Always, for many, many appointments and for many elective offices, you have to be at the right place at the right time. And there are years when Democrats are elected and there are years when Republicans are elected. With the result that there are years when Democrats are appointed to the bench and years when Republicans are appointed. You have to take that into account, and there is no good way to measure it. But that is important. Each administration tries to claim that they've appointed quite a number of people of the other party, but I think the facts show up that it's a very small minority of the appointments made by a Republican president that go to a Democrat, and in turn very few appointments of a Democratic president that go to a Republican. So you have to take the political situation into account. You have to take the age of the person into account. At least when I was appointed, it was believed very difficult to secure an appointment if you were 60 years of age or older. Then, of course, the amount of business that you had, that becomes important. In the early days, it used to be said, perhaps the Civil War times and in through there, that the lawyer who had good business was likely to be appointed so that the other lawyers could divide up his business when he was on the bench. And I'm told that there was maybe some truth to that.
Mm-hmm. Your relationships with the United States Court of Appeals for the Eighth Circuit during your active years and, of course, now during senior status, has that been a warm and good working relationship?
I think it has been a very warm and good working relationship. I've had a number of very close friends who have been men who are on the United States Court of Appeals for this circuit. Persons that I didn't know until I became a district judge, and then was called to sit with them and become acquainted in that way. Mm-hmm. I have a high regard for the Eighth Circuit Court of Appeals.
Of course, even in your earlier career as a practitioner, inevitably you were to encounter some members of the Court of Appeals.
Yes, there would be a few cases that you would argue and have that opportunity, and you would see the members here and there also.
One of the legendary figures was Judge Woodruff.
Yes.
Can you tell us your early recollections of him?
Yes, I became acquainted with him when he was the sole judge on the district court in Omaha. I think the first matter that I handled before him was up at Norfolk, Nebraska. I had filed a claim on behalf of a bank in northeast Nebraska against a man that was in bankruptcy. I'd filed it in the bankruptcy proceeding, and the bankruptcy referee disallowed our claim. It surprised us very much. I took an appeal to the district judge, which was the procedure at that time, made a statement to Judge Woodruff that involved was the question of the validity of the signature on the note, that we had evidence in the record that showed that the proceeds of the note had gone into the man's bank account, and the checks that he had written and had drawn out all of that money. Then we had a number of exemplars that were used by one or two experts who testified that it was the man's signature. I'd gotten about that far along with the statement when Judge Woodruff interrupted me and said, Mr. Van Pelt, you know that I'm a handwriting expert, don't you? And I had to say, well, no, I didn't, and apologize and turn red-faced probably. And then he said very suddenly, hand up the note to me, hand up the exemplars, which I did immediately. We sat there, I don't know if it seems like a long, long time, but I would expect we did sit there 8 or 10 minutes at least, in which he very definitely was just intently examining the exemplars and the signature. And just all of a sudden, out of the clear sky, says, no question about it at all, that man signed that note. When you get back to Lincoln, write an order reversing the bankruptcy referee and allowing your claim with interest as the note recites. That ended the thing. Didn't give the other side a chance to answer anything, and I found that that was typical of him. Judge Perry and I tried a case before him one time where when the opening statement was made, Judge Perry made a motion which was not uncommon in the early days of my practice and before that, of making a motion for directed verdict based on the opening statement that was made. And Perry had no more than finished the motion, which usually would be denied by a judge, and Woodruff said, motion sustained. You haven't stated enough here to constitute a cause of action. We're not going to spend any time on this case. So he just moved right on to the next one. He was a very human man, and you know some of the stories about him, walking 145 miles from Omaha up to Norfolk to hold court, and things of that kind. But very, very human gentleman.
He was legendary in terms of his walking, and yes, the young men who had been his clerk were sometimes worn out by him, even in his later years, because he wanted to keep moving around. It was said that he was a marvelous sidewalk superintendent as well. Whenever yes, something was going on, he'd pause briefly and take a look at it. There was a wonderful story in the history of the Eighth Circuit that when the court was sitting down there, he'd walk all the way across the river into East St. Louis and then perhaps have a meal and then come back and be back at court in time for the early morning session. of the court. Quite a peripatetic gentleman, I should say.
Well, it was not infrequent for him to walk from the courthouse here in Omaha. You recall the location down to Johnny's in South Omaha and eat lunch and walk back.
The most unusual for us to be looking back on a gentleman like that. It is also unusual, it seems to me, for an individual to move from the district bench to the United States Court of Appeals. At least our experiences here in the Midwest indicate that so. He was, of course, the exception to that rule.
He is the only one in Nebraska who has moved that way. Munger, it looked like, was going to be appointed to the Court of Appeals, and just at the very time, Senator Norris threw in a block on him because he thought that Munger had entered an injunction in a labor case that should not have been entered by a district judge. Later, Norris said that he believed that he was mistaken and that Munger should have been appointed, but he didn't make it. John Delahunt undoubtedly would have been on the Circuit Court of Appeals, but Judge Woodruff concluded that he should stay on, and so he stayed on out beyond where there was any chance for Delahunt to be appointed. When there was talk up about my being appointed, Lyndon Johnson concluded that he wouldn't appoint a Republican. And, so you have to be at the right place at the right time.
That's right. What about Judge Donahue? We haven't said much about him yet this morning, and he's certainly a colorful fellow.
I think he was a very unusual man, and perhaps never appraised to the full extent that he should be. He introduced in the Nebraska legislature, as a state senator, the first bill that was ever introduced in the United States calling for nonpartisan election of the judiciary. He didn't get it through the first session, and later a state, I believe maybe Montana, but I could be wrong about the state, passed such a law. Donahoe got it through either 2 or 4 years later, but it was a great step forward in the judicial process. He was also a member of the Constitutional Convention in 1919 and was outstanding. And he, of course, became the judge when Woodrow was appointed to the Circuit Court. And you may recall that there was a letter called the Dear Arthur letter, which the President had written Arthur Mullen, commending him highly and so forth, and but not appointing him to the Circuit Court, and likewise he didn't appoint him Attorney General, which is what Mullen actually wanted. And Mullen and Donahoe had been good friends. The result was that Mullen endorsed Donahoe, and he was appointed, and I think was an excellent judge. He had one interesting thing that, again, would be something to try someday, maybe. He mainly held court from 10 to 12 and 2 to 4 without recess. Recess at noon, yes, but he'd get in 4 hours of court time without any recess. He got a lot of work done. He was I think, a very competent man, very honorable man.
The geography of our state is such that the United States District Court, which is, at least in my experience, always sat for a period of time out in North Platte. Each judge, as I understand it, has rotated, going out to North Platte for a month or whatever is necessary to do the job. What are your recollections about that kind of rotation?
Yes, originally we held court in 8 places. Omaha, well, originally only held court in Omaha, and then Lincoln was added. Then still later, there was added North Platte, Grand Island, Hastings, McCook, Chadron, and Norfolk. That system continued until Judge Delahunt was the judge. The division was that the Lincoln judge handled Lincoln, Lincoln, Hastings, and McCook. And the Omaha judge handled the other 5 stations, the Lincoln judge helping out, usually by going out to Grand Island. At the time that Don Ross was Republican National Committeeman, Ross and Delahunt made quite a study of it, And Ross is entitled to a great deal of credit in following the suggestion, I think, of Delahunt, that they eliminate 5 places. Without doubt, you could get to the 3 places where we now hold court by modern methods of transportation much easier than with a lumber wagon. You could get out to Chadron or to McCook or someplace like that from another point in western Nebraska. But in the fairly early days of Delahunt's administration, they discontinued 5 places. I understand also, and this is simply gossip, that they very seriously considered holding court in Grand Island and concluded that it wasn't entirely fair to the Hastings bar to hold court in Grand Island and no longer hold court in Hastings, and so they eliminated both of them. I couldn't prove that to you.
There used to be wonderful stories about district judges and the whole entourage of lawyers who would be in North Platte for however long the court was sitting there, and they would have not just the business of the day, but also an opportunity to sit around and swap yarns in the evenings. Is there any truth to those stories?
Well, I'm sure there's truth to those stories, and similarly, I believe at one time the main lawyers in Columbus, Nebraska, adjourned at 5 o'clock each day and went to a certain place in Columbus where they spent the next hour or hour and a half and disposed of lots of business during those times, I'm sure.
In your own professional experience, you, of course, as a judge, have done things other than just be a judge. You were extremely influential with regard to some of the uniform rules that we use, particularly the federal rules of evidence. Tell us a little bit about
that.
Your
is an
involvement
interesting
in that.
story, if I can tell it accurately. Harvey Johnson wrote a letter early in the time that I was a judge, and Harvey and I had been in law school together. Wrote a letter to all of the judges calling attention to the next judicial conference and asking each judge to make a suggestion as to what they'd like to have on the program. I wrote to Harvey and said I would like to hear somebody report on the evidence cases decided by the Circuit Court of Appeals during the year. We all try to read them, but I'd like to hear some discussion of them. And my end of the story is that Harvey said, nobody needs it any worse than you do, I'll assign it to you. Anyway, Harvey assigned it to me, and last year I gave my 25th paper on evidence. Now that is the background to the next thing that comes along. There was appointed, I believe, 3 professors to make a report on whether or not the evidence, whether a study should be made of the evidence rules and rewriting the rules, writing the rules of evidence. And these 3 concluded that there should be a revision made. So it was left to the appointment of a committee of 16 persons. 3 were federal judges, 3 were university professors, and 9 were from the practice of law. I was fortunate to be one of the 3 law school, one of the 3 judges to be appointed, and I'm sure I was appointed largely because out in the 8th Circuit, it was by that time known that here is this fellow that reports on evidence cases. I have never claimed to be an evidence expert. I do claim that I've written a lot of papers on the subject, but I still don't claim that I'm an expert. Well, anyway, I was called on then and permitted to serve on that committee and served on it for 10 years. Earl Warren wrote me the letter, and I called Harvey Johnson about it, whether I should accept it. I felt I had to have his approval before I accepted such a thing, and he was very positive that it was a must, that of course I should accept the appointment. So I'm glad it was tendered to me and that I had the opportunity. Then I was appointed by Chief Justice Berger to the committee to implement the Magistrates Act, and I was also appointed to the committee on, sometimes called on judicial ethics, but that interprets first the American Bar Association's Code of Judicial Ethics, and then later the code as adopted by the Judicial Conference. And I'm still serving on that committee, where we will write and answer an inquiry of any judge or any United States magistrate or any United States bankruptcy judge that they want to raise under the code of ethics governing them. So those have been outside assignments that I've much enjoyed.
And extremely important ones.
And I've had the opportunity of sitting with half of the circuits exactly, and I had to turn down 2 other circuits. So I've had a pleasant experience with the courts of appeals.
Over the years, there have been some major changes with regard to the utilization of magistrates in our judicial system. What are the principal changes that you have seen that you think are beneficial to an efficient operation of the courts?
Well, I think it is beneficial to give them added jurisdiction and permit them to try many cases that perhaps we could call them misdemeanors, and yet they're not entirely misdemeanors, but giving them more and more authority to try cases, to rule upon or recommend rulings upon motions, and to be assistants at least to the judges.
And of course, in our own jurisdiction, we have moved from having a part-time magistrate in Lincoln now to having a full-time, worked in conjunction with Magistrate Peck here in Omaha, and I'm sure that must be at least a relief some of the docket congestion.
Yes, I think it is. We have now 2 full-time magistrates in Nebraska. Dave Peaster in Lincoln, in addition to Mr. Peck, who is a longtime clerk of the court and a very, very competent man. Then we have 1 bankruptcy judge, and it's in the works for Nebraska to have a 2nd bankruptcy judge. The bankruptcy volume has been going up so tremendously that I think anyone who makes a study of it would conclude that 1 man can't handle all of the bankruptcy cases.
I should certainly think so.
The young man that we have is a graduate of your school here. You may know him.
Jim Mahoney.
Doing a very good job, but the amount of work is just tremendous.
We had the pleasure just the other day of having Judge Mahoney come over and motion day in the law school so the students could observe the lawyers before him. A nice addition to the other kinds of judicial experiences that both of the law schools in the state are able to share nowadays. And speaking of that, you had taught for some period of time at the Law College down at Lincoln.
Yes, the law school at Lincoln discontinued its work when World War II came along. Didn't open up until, I think I am correct in saying, the spring of 1946. It could be that it was in the spring of 1947. The man who had been teaching conveyancing had not yet returned, had just returned from the war, and he didn't want to take the course. Dave Dow, who's my friend and dean of the college, or later dean of the college, came to me and asked me if I would do it. They were giving courses and wanting to graduate a group of people in August. And so I took it on and stayed with it for 10 or 11 years. My early experience, as I earlier indicated to you, was law office examining a lot of abstracts. I never would have expected to go over and run a course on real property.
But that must have been a marvelous experience for you.
A marvelous experience. I'm talking too much about myself here, but let me tell you of another experience I had with your school here that was a great experience for a relatively young man. 1937, we had the first unicameral legislature. Charles A. Defoe of Tecumseh was picked that year by Time magazine as the outstanding legislator in the first unicameral. He was later killed during the war as Captain Defoe. He hit on the idea that the legislature should have some lawyers to pass on the constitutionality of bills that were introduced in the legislature. And he had the influence to push it through, and he proposed that Dean Tupul of Creighton, Dean Foster of the Nebraska Law School, and some appointee from the Attorney General's office be the committee of 3 to pass on all questions of constitutionality. Dean Foster refused to accept it. I was asked to take his place on the committee. It was a great contribution to the life of a young lawyer to spend that spring working about half-time and coming in contact with Dean Tapool, who was one of the great constitutional lawyers of our country at the time that he was at his prime. And I must give credit to having a great opportunity there, and in a field that I think would still be good for the legislature to have, but the governors don't agree. I've talked with more than one governor about it, and they do not want the ones I've talked with, do not want the legislature to have counsel of their own. And I'm not going to debate these.
I think one can understand why a governor might take that point of view. You saw the transition from the old bicameral system of legislature into the unicameral, and you were there when all the debates were going on with Senator Norris and Congressman Norton and Professor Sennett. How do you view the work of a lawmaking body in this newfangled modern scheme that we alone in Nebraska have adopted?
I still think it is all right, but I don't think it is all right to do some of the things they're now doing. It should be a non-political legislature. Hence, I do not agree with the Republicans organizing and the Democrats organizing and organizing as components of a political party. I think they should continue to be a non-political legislature, and that if they would do that, we'd have a much better legislative session than we have now. There are others that may know more about it than I who take exactly the opposite position on that.
It's been interesting over the years. There have been some attempts to get other states to adopt a so-called nonpartisan unicameral legislature. Nobody seems to have been interested in adopting our experiment.
I think that's right. There was one or two states in the history of the Republic that had a one-house legislature back maybe 100 or so years ago, but I can't tell you who it was. It seems to me it was up in New England, one of the states at least.
In the early history of our United States courts here in Nebraska, a very colorful gentleman by the name of Judge Dundee. What are your recollections, at least apocryphal, about him?
Dundee was an interesting character. Of course, I didn't know him. He came into Falls City and began the practice of law and also farming down there. He was the first federal judge appointed in Nebraska and was a territorial federal judge. Then he was later appointed, when statehood came, the federal judge for the District of Nebraska. In reviewing his history, it's interesting to know that when he was a territorial judge, he was in effect impeached by the Bar Association down in Nebraska City in October, I believe, of 1862, and within 2 or 3 weeks, the Omaha Bar Association voted to set aside all of the Nebraska City proceedings. You must evaluate these men by circumstances, I think, that and the rules of their time. Dundee was an active Republican all of the time that he was on the bench. He attempted in the days when the legislature elected United States senators on more than one occasion to be elected the United States senator. He rode on a railroad pass everywhere that he went, had a special car when he would go out to North Platte or places like that. Yet he recognized legal principles without question, and was the person in the Standing Bear case who said that an Indian was a person and had a right to bring an action. As I recall it, one of the defendants was General Sherman of Civil War fame. Took a lot of courage for a federal
revolutionary opinion for that period of time.
To stand for the things for which he stood. So you have two sides on Dundee. One person that I would not quote by name, who has written about some of the judges to me confidentially, now dead, said that he was not a great student or a great scholar, but he's a very practical fellow and evidently got things done.
A remarkable story. We've been visiting this morning with the Honorable Robert Van Pelt, Senior United States District Judge for the District of Nebraska, a universally respected jurist, a man of the people, a man who's beloved by all members of the bar who've had the opportunity to know and work with him. Thank you, Judge Van Pelt.
I appreciate it very much, and I'm honored to be invited to be here. Thank you.